Hello and welcome to the Radcliffe Commercial Talks. Today that's being given by myself and Martin Ouwehand. And what we're going to be talking about is problems that really arise or can arise in relation to shares and how to rectify them. And we're looking at it mainly in relation to what might come up in a due diligence process, but it might arise in other situations as well. I'm going to be dealing specifically with purchases by a company of their own shares, and Martin's going to be dealing with other problems that may arise. So let's look at a situation. You're acting for a client who's proposing to buy all of the shares in a company. And I'm only going to talk about private companies because this is where most of the situations arise. And therefore, you're carrying out due diligence. And whilst you're carrying that out, you discover that in the past, the company has, in fact, purchased its own shares. So, what you have to do is obviously investigate those purchases to see whether or not they're valid. And surprisingly, this is actually an area where lots of mistakes can be made. Now, whilst I'm doing this in the context of maybe share purchases and a due diligence exercise, obviously it's not confined to those situations. So, for example, it may be something that arises if a company goes into liquidation or administration, and during the course of the office holders' investigations, these issues arise. Or there could be a change of governance of a company, or possibly it could arise in the context of shareholder disputes. So I'm going to essentially divide my talk into two parts. The first part, I'm going to deal with what you should be looking out for and whether if mistakes are found, they're actually fatal mistakes. And in the second part, I'm going to be looking at what action you can take if the mistakes are in fact found to be fatal. So dealing with the first part, if in fact, as a result of your due diligence or other investigation into the company's affairs, you come across any material that shows that in the past the company has purchased its own shares, you will need, first of all, to collate as much material as possible relating to those share purchases in order to form a view as to their validity. Now, the part of the Companies Act that you need to be looking at is Part 18, which deals with acquisitions by a company of its own shares. And Section 658 provides that a company must not acquire its own shares, whether by purchase or otherwise, except in accordance with the provisions of Part 18, and that if it does so, the purported acquisition will be void. Therefore, it will be important to ensure that share purchases that come to light have in fact been done properly. And there are a number of checks that you can do. First of all, you must ascertain when those share purchases were done. And the purpose of that is to really work out what was the law that applied at the time. And for the purposes of this talk, I'm going to assume that the current law applies. And then you're going to then need to check whether or not what I'm going to call the substantive requirements have been complied with, and then whether the procedural requirements have been complied with. So first of all, dealing with the substantive requirement, these are the questions that you need to ask. I've dealt with the law at the time of the purchase. The next one is whether or not whether the articles of association that applied at the time of the purchase contained any restrictions relating to the company purchasing its own shares. And you need to see Section 690 of the Companies Act. If so, you actually need to then check what the restrictions are and whether they affect the sale in question. And the most obvious restriction is if the articles actually prohibit the purchase by a company of its own shares. But the article could alternatively prohibit a purchase unless certain conditions are complied with. The most obvious condition is that if there are any preemption provisions in the articles, which would cover also as a matter of construction, a sale of shares to the company. And in those circumstances, you need to see whether or not those preemption provisions were complied with, or alternatively, whether waivers were obtained from the other shareholders. Secondly, you need to ensure that the effect of the purchase was not to leave behind only redeemable and or treasury shares. Um, and that's section 690, subsection 2. Although I have to say, in the whole of my time when I've dealt with that, I've never actually come across a situation where that has occurred. Thirdly, you need to check whether the purchase was financed from a permitted source, and the permitted sources are set out in section 692 of the Companies Act. They are, first of all, the distributable profits of the company, or the proceeds of a fresh issue of shares. Thirdly, payment can actually be made out of capital, provided the provisions of Chapter 5 of Part 18 are complied with. And those requirements essentially include the following. First of all, that you have to first of all use up all of your distributable profits and also any proceeds of a fresh issue of shares. And it's only then that you can then resort to the capital. So that's the first thing. Also, you have to have a director's solvency report, which is supported by an auditor's report, solvency statement rather. And also you need a special resolution of the shareholders, and there's some other requirements as well. Finally, there is a company may be able to use its capital to purchase the shares without going through the Chapter 5 procedure, if it's actually authorised, first of all, by its articles, and if the aggregate purchase price in a financial year is the lower of 15,000 or the nominal value of 5% of its fully paid share capital at the beginning of the financial year. Fourthly, you're going to have to check whether the shares purchased when they were repurchased were fully paid up shares, and that's section 691. And finally, you need to check whether the shares were paid for on purchase, although there is a limited exception to this in respect of employee share schemes, and this is section 691, subsection 2. Now, I have to say, I think this is where a lot of share buybacks actually fell. And this provision really raises two matters that you need to be aware of. The first is that whether the consideration itself for the purchase has to be a cash consideration. Obviously, if cash was paid by the company, that's not a problem at all. And likewise, it would appear that if the seller has a pre-existing liability to the company, a set-off of that liability against the purchase price will be sufficient to say that it's been paid in cash. Now, there are some authorities where there's some obiter dicta, and it's merely obiter dicta, that payment might be able to be made otherwise than in money. But there's actually no authority that actually expressly decides that that can happen. And my own view is, I have to say, that I think that it has to be a cash consideration and that a non-cash consideration will not be sufficient. And one of the reasons I say this is that there is no provision in the Companies Act for if there's to be a non-cash consideration as to how that non-cash consideration is to be valued. Now, the second matter that's raised from this, and this is one that is really a common problem and that people actually miss, is really raises the timing of the payment because payment has to be made on purchase. So, for example, you can't have a payment to be made by instalments, and that happened in the case of Kinlan against Crimmen. Nor can you have a case where of a purchase where the company acknowledges to the seller that it owes the purchase price to the seller. And that's what happened in the case of Dickinson against Null Realizations, where the price was left outstanding on a loan account on completion, with the debt acknowledged by the loan agreement between the parties. And what Lord Justice Newey said in that case, that it was not enough if a contract of sale provided for payment to be made forthwith, it actually had to be made on purchase. Now, if any of those substantive provisions have not been complied with, then the relevant share purchase will be void. So that they're actually fatal. So we next move on to, so you've been through all of those and the substantive requirements fine, they've all been complied with. So the next checks that you need to make are whether or not the company has followed the appropriate statutory procedure. And again, this is where quite a lot of the problems may arise, and again, quite surprisingly so. In this respect, I'm only going to deal with off-market purchases, as these are the ones where the mistakes are commonly made. And an off-market purchase is defined by Section 693(2) of the Companies Act as a purchase which is otherwise than on a recognised investment exchange, or a purchase which is on a recognised investment exchange but is not subject to a marketing arrangement on the exchange. So such purchases have to be made pursuant to a contract, which itself has to be approved in advance in accordance with Section 694 of the Companies Act. And that provision that provides that either the terms of the contract must be authorised by an ordinary resolution of the company before it's entered into, or the contract must provide that no shares may be purchased in pursuant of the contract until its terms have been authorised by a resolution of the company. Resolutions, whether at a meeting or a written resolution, must also be called and held or carried out in accordance with the provisions of the Companies Act, and where relevant, also the company's Articles of Association. Now, we need to look at actually who can vote on these. So where the resolution proposed is a written resolution, a member who actually holds shares to which the resolution relates is actually not eligible to vote on a written resolution, and that's in Section 695, subsection 2. So that effectively means if the shareholder is a sole shareholder, he can't use the written procedure, although in that situation, I can't imagine that he's going to be selling all his shares. But the problem is if the shareholder is also seeking to sell only part of his shares, he also cannot use that written procedure. He's just not eligible to do that. Where the resolution is proposed to be made at a meeting, it's not effective if the shareholder votes, and the resolution would not have been passed if he had not done so. So whilst under this provision, a selling member actually can vote, and if he does, his vote would be discounted. If the company's articles are governed by the model articles, regulation 37(2) of those articles, in fact, disenfranchises such a person altogether from voting. Further, a resolution seeking to confer authority for an off-market purchase is not validly passed if the requirements of Section 696 are not complied with. And those requirements are, first, a copy of the contract if it's in writing, or a memorandum setting out its terms, if it is not in writing, must be made available to the members. In the case of a written resolution, by being sent or submitted to every eligible member at or before the time at which the proposed resolution is sent or submitted to him. And in the case of a resolution at a meeting, by being made available for inspection by the members, both at the company's registered office for not less than 15 days, ending with the date of the meeting, and at the meeting itself. So examples of problems that may come to light when you're looking at this include the following. So you might, for example, not be able to find any formal resolution showing that the contract of purchase had been approved before it was entered into. If a meeting was held, it may be clear that a copy of the contract or a memorandum of the contract, in fact, was not kept at the company's registered office or at the company's registered office for the 14 days before the meeting, or was made available at the meeting, or that, in fact, there's no evidence one way or the other as to whether that happened. And proper notice of the meeting may not have been given. If any of those issues arise, on their face, it may be considered that the purchases then are invalid. However, actually, this may not be the case if we can apply the geomatic principle. Now, under this principle, where it can be shown that all of the shareholders who had the right to attend and vote at the meeting assented to some matter which a general meeting of the company could carry into effect, that assent is binding as a resolution in a general meeting would be. Now, the cases appear to show that the geomatic principle will be applied, assuming that you can actually evidentially prove that there was informal unanimous consent with the shareholders. But whether it will be applied will depend upon whether the purpose of the requirement is solely for the benefit of the shareholders alone, so that they can be said to have waived them, or whether it's also for the protection of creditors, or there's a wider protection that you need to be looking into. So therefore, we need to really consider two situations. We first of all need to consider whether the geomatic principle can be applied where there's been no formal resolution at all, or at least you can't find one. And secondly, if there has been a formal resolution, you can find that, whether it can be applied to other procedural defects. So dealing with the first situation where there's no formal resolution, in the cases of WP Kings Lynn and Kinnan against Crinan, the court held that a formal resolution had to be passed and that the re-geomatic principle, in fact, had no application. The reason given in RWP was that a formal resolution is required not only for the protection of the members of the company, but also for the protection of its creditors, as well as possibly serving a wider public interest. In Kinlan against Crimlan, the judge said that a formal resolution, although primarily for the protection of the shareholders, was not solely for their protection and had to be kept as part of the company's books and records, which could be inspected by others in the future. And obviously that would include in the future shareholders or office holders if the company goes into a formal insolvency process. Now, there's only one case that potentially opened the door to the court applying the geomatic principle to a decision to approve the share purchase contract, and that's the case of Dashfield and Davidson, although I think this case is really confined to its own facts. Now, what happened there was that there was a resolution amending the company's articles by providing for the purchase by the company of a deceased member's shareholding. The court accepted that such a contract could be contained in the articles. The difficulty was that technically there had been no resolution to approve the contract proposed to be included in the articles before formally approving the amendment to the articles, which was when the contract was entered into. The court recognised that there was no minimal time requirement between approval of a contract and its being entered into, and that the latter could have occurred, could occur seconds after the former. The reality is that the court could not believe that where there was only one piece of paper with the composite transaction instead of two bits of paper, it could possibly have been in the mind of the legislators that this was the sort of transaction that should be struck down. It was artificial to consider which of approval or execution came first. The court questioned, therefore, whether there was in fact non-compliance with the Companies Act, but does appear in the circumstances of the case to have been prepared to apply the geomatic principle if there had in fact been any non-compliance by the agreement being executed a scintilla of time before the approval. The court made the point, however, that this case was actually different from RWP, where in that case there had been no power of the company to buy the shares and there was no resolution to approve the contract. In conclusion, my own view on this is that in light of the current authorities, a formal resolution is required and it's not sufficient to rely on re-geomatic. Now, in relation to the other procedural requirements, for example, the period of notice given for holding a meeting or keeping the contract at the company's registered office for the requisite period of time, it seems that the courts have actually rowed away from RWP. RWP was actually very strict in its application, and it permitted no deviation at all from any of those requirements in respect of off-market purchases. Now, this was actually shown in particular by the case of Kinnan and Crinan, and what was said in that is that these procedural requirements are solely for the benefit of the shareholders. So, for example, keeping the contract at the registered office is so that shareholders have time to consider whether they wish to approve the contract. As such, because they're only for the benefit of the shareholders, they can be waived by the shareholders under the geomatic principle. In the Kinnan case itself, all of the relevant shareholders who were also directors of the company were actually shown the proposed contract at a shareholders meeting. So there hadn't been put at the registered office for inspection, but they had been shown it at the directors' meeting, and therefore they knew of the context of the contents of the contract, and therefore geomatic applied. Likewise, if a meeting is called on short notice and all of the shareholders in fact attend the meeting and vote in favour of the contract, they will be held to have waived the notice period for the meeting under the geomatic principle. The geomatic principle, however, is unlikely to help, for example, and I just give this by way of an example. Say, for example, if one or more of the shareholders actually not shown the proposed contract of the memorandum of it, and that contract has not been placed at the registered office for inspection for the requisite period. And if that shareholder, for example, is given notice of the meeting, but he doesn't attend for one reason or another, and the general meeting then go on to approve it. In such a situation, it has to be seriously doubted whether there has been a valid resolution and whether or not actually the geomatic principle can be applied. Finally, just on procedural checks, you should note that a failure to comply with Section 07 of the Act and to file formal returns at Companies House after the purchase has taken place, provided obviously it's been carried out lawfully. If you fail to do that, that shouldn't invalidate the purchase. And if you want authority for that, there's the case of NL Electrical Limited. Sorry, I should have gone to that one. So the next question is what to do if any of these problems arise. So now this may depend really on what situation you find yourself in. So for example, if you're representing somebody and there's a potential purchase, now, I don't know what the timescales might be like that, but there may be a potential purchase. The potential purchaser might be in a hurry. There might be some urgency to purchase the shares. So the steps that you might take might be different depending on what the situation is and what the problem is. So you actually have to look at this depending on the context. So, for example, if you're a liquidator or administrator, you might take steps which are very different from what a potential purchaser might take. Now, as I've already said, not every failure to comply with the statutory requirements will make the share purchase void. However, if the share purchase is void, you may wish to consider whether or not to take any of the steps that I'm about to take you through. Now, however, what you may or may not want to do may not actually be obvious, and I say may depend on the particular circumstances of each particular case. For example, you may have to consider whether the buyback was part of a wider transaction, and if so, how that should be dealt with in its context. Other problems may also arise. For example, there might have been dividend payments in the interim, which would have been larger for the shareholders receiving them because of the belief that the shares that have been purportedly purchased no longer existed. Now, I'm just going to move to the next. Now, the starting point is because the purchase is void, the shares purportedly sold will not have been cancelled, so they continue to exist, and the seller will still hold legal title to them and will be liable to repay the purchase price. Now, if the company's happy with that situation, the most obvious step is assuming, first of all, that the limitation period has not expired and that the seller is likely to be good for the money. Most obvious step is then to seek restitution of the purchase monies from the seller and to rectify the register of members. However, if the seller doesn't have the money to make the repayment, um, the company might consider whether or not the way maybe to deal with that, if it doesn't want the seller to go back on the register, is whether it would be able to declare a dividend just to that to the seller, with the other shareholders agreeing to waive any right to dividend, and then with the dividend then being set off against the liability of the seller to the company. But that's going to depend on the company's particular circumstances, and the directors are going to have to consider quite carefully their duties to the company and whether it's in the interests of the company as a whole to take that step. Um, Alternatively, say, for example, that recovery of the monies is not possible to recover from the seller. For example, because the seller's not got the money, and the seller may have become bankrupt in the meantime. Another possibility is, if they want to sort of consider that route, is to consider whether there are any claims for breach of duties of the directors who were the directors at the time of the purchase. But there may be, for example, reasons why a company doesn't want to have to reinstate, the seller to be reinstated as a member of the company, or to seek restitution of the price. And that's going to be particularly so if the company's in liquidation or administration. But there may be a case also where there are good commercial or legal reasons against restoring the selling shareholder to his previous position and seeking restitution. Now, in this situation, you may want to consider the following possible solutions. First of all, subject to a seller and the other the other shareholders' willingness to cooperate, it may be possible to effect a new purchase by the company of the relevant shares, provided that the relevant provisions of the Companies Act can be complied with. Now, in this scenario, the purchase price would be paid by the company by setting it off against the seller's liability to repay the price in respect of the void sale. As I've said, in relation to that, this set off would amount to a payment in cash. So payment would therefore be treated as having been made on purchase. Now, the problem with this is that a seller might actually be difficult, and what they might seek to do is to extract a higher purchase price than they originally agreed to sell their shares for. And that might apply because, for example, the company is in a much better financial position than it was at the time of the original purchase, or really the seller's just really trying to extract whatever it can to allow the company to extricate itself from the situation. Now, then, in that situation, the company is going to have to decide whether or not it's willing to pay that higher price, or whether it will enter into a negotiation with the seller. Whether or not also the company deals with it in this way may depend on, so far as the seller is concerned, whether or not going this route might affect the seller's tax position, in which case agreement might have to be reached between the seller and the company as to how best to ameliorate that situation. The second possibility is that instead of either seeking to recover the price or to effect a new purchase, the company might be able to carry out a reduction of capital and seek to cancel the shares which are the subject of the void purported purchase, and to do this under Chapter 10 of Part 17 of the Companies Act, in exchange for the company releasing the former shareholder from returning the proceeds of sale of the company. to the company. Now, if you're going to consider doing this route, it's better that you don't go the out of court route for a reduction of capital, but you follow a court approved route. And the reason for this is that if the company confirms the reduction of capital and the company then complies with its duty to deliver to the registrar of companies the order and a statement of capital, which the registrar of companies then registers, the registrar must then issue a certificate regarding the registration of the order and statement of capital, and that will be conclusive evidence that the requirements of the Companies Act in respect of the reduction have been complied with, and that the company's capital is as stated in the statement of capital. Now, if you're going to follow that route, then the company is going to have to pass a special resolution cancelling the shares purportedly acquired by it on the basis of the reduction taking effect. Upon the reduction taking effect by the holders of the when the former holders of the council shares are released from all liability they might have to be repaid to the company. Sorry, excuse me for a minute. I've just got a bit of a cold. As regards dealing with those formalities, the purported sellers, in fact, you don't need to notify them of the meeting for that resolution. But they will be required, because they're no longer shareholders on the register, so they're no longer members of the company, but you will be required to give them notice of the application itself for the reduction to be approved by the court. So in order for the reduction to be approved, the court will ensure that the reduction is not to the detriment of creditors. Usually the court will be satisfied with this if the company is solvent. It will also need to be satisfied that the purported seller was in fact paid all of the purchase price and that the shareholders, including the selling shareholder, is being treated equitably. Now, using the reduction of capital route is actually quite a common way of resolving the problem of a void share purchase. And I have to say, I was recently sitting as an IC judge. I had just one such case coming on before me, where during a due diligence process, it was discovered that there was a buyback of shares, in fact, going all the way back to 2008. And it was believed that it might have been void just because of the passage of time. For example, the resolution couldn't be found. And so therefore it was decided that there was no point dealing with it in any other way, and the best way of dealing it was applying to the court for a reduction of capital. Now, as to the timing of that application, if reduction is seen as the best route, there's going to have to be a commercial judgment as to whether you do that before or after the purchase, and it may depend on really the urgency with which the purchaser wants to purchase all of the shares. So they may not have the luxury of doing everything before the purchase. However, if that effectively happens, then it might cause problems later on. For example, the longer it goes on, then it may be more of the evidence more of the evidence disappears, or it may be that later on, if the purchaser doesn't really do anything about it, and later on the purchaser then wants to onward sell the shares, that it then is raised in the due diligence of a future potential purchaser. So, just whilst we're on reductions, there may, however, be situations where, in fact, you cannot go for a reduction of capital. And that will be, for example, where your share purchase is void because there wasn't payment of the price on purchase, and you've just left the price open to be payable as a loan, and nothing, in fact, was ever paid by the company. So in that sort of situation, there is no liability of the seller to pay back anything, and therefore no justifiable purpose for a reduction of capital. There's one other final alternative that buyers may wish to consider, And that is actually to take out an insurance policy in case a future claim arises in respect of a share purchase by the company, which may later prove to have been unlawful, or which cannot be shown to have been unlawful because documents which may have existed have been lost. And in that sort of situation, I think you can get insurance quite quickly. It's likely that insurers will fund proceedings for a reduction of capital, and it may be that if this fails or is not possible, they may also compensate the purchaser for not, in fact, managing to obtain 100% of the shares. Although this solution might offer an alternative where the problem is discovered at the last minute and there is an imperative for the purchase to take place, it may, however, not be an ideal solution for a number of reasons. First of all this solution does really is to delay the issue until a future date. As such, it may not be on, as I say, a purchaser's priorities when taking over the company, but when the purchaser does come to deal with it, some of the primary evidence might no longer be available. As I say, secondly, if the purchaser then decides to sell the company without having dealt with the problem, it's obviously going to be raised on further due diligence. So I hope that's, sorry, it was a fairly quick run through of that, and I hope that's helped you on that issue. I'll now hand you over to Martin.
Right, thank you, Tina. Good morning, everybody. I was going to just, on the end of that, deal with a couple of issues that may come up in due diligence. Of course, many issues could be dealt with by warranties or indemnities or waivers in the documents, but some issues may not be able to be fixed at all, and I think they're the ones that you need to be spotting in due diligence, both from the perspective of the buyer and the seller. It may be that some of these could be fixed by court proceedings, but there may not be time. It may be that what the vendor should be doing is doing its own due diligence before considering a transaction, so that it can take steps to make sure that when it is in a live transaction and due diligence is being undertaken, that these issues are being spotted and dealt with. So I was going to look at two. The first one is unauthorized transactions, sort of more generally, and the kind of issues that would jump out there. And the second one is really about the share register, which is obviously very, very important. So examples of issues that may arise from a lack of authority in the board to pass a resolution may be the failure to pass any resolution authorising a transaction that's important to the to the share sale. It may be a failure to properly convene a meeting by not giving adequate notice. It may arise out of a lack of quorum for the board. And it may arise out of a lack of compliance with articles. So, for instance, and this came up in one of the cases, you have a failure to obtain adherence with a shareholders agreement, which may be an issue if the buyer isn't buying all of the shares. So I think what you're keen to do at this point is assess the risk of any disputes, both from the seller's point of view and the buyer's point of view, and what may concern the buyer and may be a problem after the sale is completed. So there may be issues about the validity of security arising out of resolutions which may have been unauthorised. There may be issues about share allotments or issues which may come back to haunt the buyer. You may have issues about the validity of share transfers between sellers or other shareholders. This may arise out of whether preemption rights haven't been respected as well. And again, going back to the factual scenario of the articles not being complied with in relation to adherence to a shareholders agreement, you may have the difficulty where some shareholders are bound by the shareholders agreement and not others. So as a vendor, you may be seeking to address that. And as a buyer, you may be considering whether you can live with that or there can be some remedy after the completion. So when you're looking at these transactions, there are a number of possible answers. The first one is whether you can rely upon good old common law apparent authority. Now, the problem with that is that it's too uncertain, because as part of your due diligence, you're not going to be able to examine all of the circumstances and work out whether the requisite circumstances were those that clothed the director or the representative with authority to enter into the transaction, for instance. So, for instance, if the representation by conduct or otherwise came from the director himself, then the other side wouldn't be able to rely upon the apparent authority of that director. So the next question is can reliance be made on the rule in Turcombe's case? Now, that rule is that the validity will not be affected by irregularities of internal procedures unless the counterparty was on notice of them. But the problem with this is it only really assists a clear outsider and only applies to usual internal procedures. And it doesn't help if the director or agent could never have had the necessary authority. So that leaves us with Section 40 of the Companies Act. So just looking at the operative parts of that provision, it works in favour of a person dealing with a company in good faith, so that's key. And it deems the exercise of the power of the directors to bind the company to deem to be free of any limitation under the company's constitution. And for this purpose, a person deals with the company if he's a party to the transaction or other act to which the company is a party. Now, that's important for reasons I'll come to. Now, such a person is not bound to inquire as to any limitation on the powers of the directors. And they're presumed to have acted in good faith unless the contrary is proved. And they're not regarded to have acted in bad faith by reason only of knowing that an act is beyond the powers of the directors under the company's constitution. So it can be quite a useful provision. So we'll just have a closer look at each of those. And the reason it gets relevant is because it may be one side or the other. Maybe wondering whether the shareholder is not bound, for instance, by the shareholders' agreement can be removed because the transaction was unauthorised and they don't fall within Section 40. Or it may be that the answer is to try to apply to rectify the share register. And then feeding into that, as I'll come to, is how complicated that would be in terms of dealing with questions of authority. So in going through the due diligence, the question at the forefront of your mind is, firstly, is the issue or the transfer outside of the, issue of the shares or the transfer of shares, for instance, outside of the protection of Section 40? Now, what might spring to mind is, well, can the company simply ratify the whole thing in general meeting? But it may not be possible. The seller may not have control of that process or be able to procure it. They may not want to try that at that point. And it may be a question of not wanting that to happen and seeing whether an aggrieved party will make any application. Now, as Tina alluded to in her section, the answer often to these questions is whether the duomatic principle can be relied upon. Again, a lot of uncertainty around that in the due diligence process, being able to assess whether the relevant facts rise to the requisite proof to be able to make out that principle, and not something that you would want to rely upon if you were a buyer. And that's principally because one of the conditions of duomatic is that those giving their assent to the transaction need to be aware of all the relevant facts. And so, of course, you have the difficulty of trying to assess what is relevant, and two reasonable people could disagree about that. You also need all of the members, that's key, to have been aware of the relevant facts when they gave their assent. And that can be express or it can be by conduct. And it must be such as to be inequitable to deny that they had assented to the transaction. But the key thing to remember is that a mere internal decision of those concerned is not enough. There needs to be an outward manifestation. So what you're doing in due diligence, if you think you're thrown back onto the duomatic principle, is looking for that evidence of some outward manifestation to see whether any of this is an issue anyway. But let's assume it's not. So going through Section 40, the first thing is there a relevant transaction? Now, if we're in the factual scenario where we're concerned about shareholders which may be holding shares for which there was no authority to authorise their allotment or transfer of the like, they can take advantage of Section 40, but only if there was a transaction. So the question there is, did the issue of the shares reduce or increase the assets or liabilities of the company? Was it for valuable consideration? Because if it wasn't, then it may not have been a relevant transaction and you're thrown back on the common law. The other issue is, was it unilateral or was it bilateral? So if, depending on whose interest it is to avoid the transaction, if you can mount that hurdle, the next question is, was there a genuine decision on behalf of those purporting to act as the board to give authority or to approve the transaction? And the question there is, are there substantial grounds for those concerned to have thought that they were acting as a board when they did so? Because if they weren't, then again, Section 40 doesn't come into play. So for instance, if the third party, the shareholder, for instance, is dealing with one director and there was not even an attempt to clothe him with authority, then Section 40 wouldn't be of any assistance. And that's really about the difference between a transaction being completely null, as if it never happened, and it merely being subject to a procedural irregularity. So let's say we can satisfy that hurdle. The counterparty needs to establish that they acted in good faith. So they have a benefit here in that the actual knowledge of the difficulty, the non-compliance with the Constitution, is not enough to show that they were not acting in good faith. But it certainly is a relevant factor. And the texts are clear that it wouldn't take much more to establish that they were acting in bad faith once they had that knowledge. So they can't sit back. They can't have sat back. They can't have turned a blind eye to what may have been going on. And once they're on notice, they needed to make inquiries. And indeed, if you're trying to establish that there wasn't good faith, you may be essentially alleging dishonesty. But again, in terms of the due diligence process, what you're doing is identifying any uncertainty around that test, because certainly good faith is something that, if it came before the court, could be determined either way, depending on the facts. Now, there's a qualification on Section 40 when it comes to directors of the company or directors of a holding company who enter into a transaction with the company. So Section 40 is qualified by Section 41. And what that says is that the transaction is voidable at the instance of the company. Now, that may be advantageous. For instance, if you're trying to see if a problematic transaction can be removed for the sale, or an issue of shares can be avoided, it may be advantageous for the company to try to avoid that. So going through your due diligence, you get to Section 40 and you identify a potential issue with say an issue of shares or a resolution approving a transaction. The next question is, was a director involved as part of that transaction? Now, the question of whether the transaction can be avoided may have been overcome if it appears that restitution of the money or property on the transaction has become impossible, or the company has become indemnified, or the transaction again is affirmed by the company. But again, it may be that there's been no occasion or there's no ability to affirm the transaction. If the director was involved and there were third parties involved, then the court has power under Section 41(6) to affirm, sever, or set aside the part of the transaction that may not be vulnerable to criticism. So you'll be identifying whether that's a prospect. Now, it may be that the director can't even, or the company, the director can't even rely upon Section 41 because the common law applies. And that's where the director was responsible for the error. He doesn't have the benefit of Section 41 at all. So, for instance, the leading case identifies, for instance, a chairman who was responsible for the transaction, responsible for ensuring compliance with the Constitution. it was said that his involvement would stand outside of Section 41. So you're asking that question. You're asking whether the transaction become non-voidable, and you're asking whether the director's part can be severed. So the last issue I wanted to quickly address was that of the share register. Obviously very important. I don't need to tell anyone that. But as a reminder, Section 112, the members must appear on the register. Section 113, every company must keep a register. Section 127, the register is prima facie evidence but not conclusive of who are the members of the company. And it's important to note that the option for a private company to elect to use a public register rather than have its own has been removed as of January this year by the Economic Crime and Corporate Transparency Act. So you need to be alive to that. So no doubt you have a laser focus on the register, and you'll be looking at, were any transactions not registered? Is it not up to date? Because there'll be potential for dispute there. Have names been added unilaterally or removed unilaterally without stock transfer forms? Has there never even been a share register? And I'm sure we've all come across that. Or has it even been lost? So the remedy there is a Section 125 rectification application if it's a straightforward dispute without a great factual dispute. And your concern there is there may be disputes between shareholders. There may be, again, breach of preemption rights. You may have an aggrieved party trying to apply to become a member or remove somebody else. There may be allegations of forgery and the like. So Section 125 may be a prospect that you're concerned may happen, or it may be something that you wish to take advantage of to ensure that issues don't arise when the company is purchased or the company shares are purchased. So Section 125 is the first port of call. It allows the company, a member of a company, or an aggrieved person to apply to court for rectification of the register of members if it either does not include information it is required to include, or it includes information that it's not required to include. Now, there may be a temptation to create a register or correct one if all the relevant information is obtained elsewhere. So, for instance, if it's in minutes or transfer forms or on Companies House, and it appears there's no dispute. Now, I think that would be very risky. There was some authority that may be an option, but recent authority is very clear. You can't simply remove names. I think it must follow that the court must be involved in any steps taken to correct, as it were, the register. And should directors try to do that, we'll call it self-help, they may be in breach of their directors' duties. So I would urge an application to be made rather than to give into that temptation to try to reconstitute the register or correct it without taking that step. The difficulty is Section 125 is supposed to be a summary remedy, as I mentioned. So if there are going to be many issues, non-compliance with preemptions, unauthorised resolutions, then you could end up in protracted Part 7 proceedings with factual disputes. And indeed, I think even an application of Section 125 may take some time to come before the courts, or may be of little use if you're just in due diligence hoping to complete the transaction in short order. On the other hand, helpfully, it's clear that the court's powers under Section 125 can be used to reconstitute a register if it never existed. It can allow retrospective changes to the register. And it can also make consequential orders to deal with what has happened while the register has been incorrect. So, for instance, it may declare certain persons to have held shares as bare trustees for the person who's been wrongly removed, and that, of course, will be important when it comes to who's been receiving distributions. Now, it may be that in your due diligence, what your concern is that an aggrieved person may apply, as I said, because they decided they've been denied membership or they're entitled to membership, or that someone else shouldn't be a member. And you'll be looking to see how long that state of affairs has been in place. Now, there is a 10-year time limit for compensation, but not for rectification, as it were. Having said that, the jurisdiction is discretionary, and so there is the option of relying upon leachees, unreasonable delay, a lack of clean hands, or where it would prejudice innocent parties. So I hope that was useful. They're the two issues that I wanted to draw to your attention, which I think may arise during due diligence and which should assist in determining whether transactions are too great a risk or whether there are steps that can be taken either by the buyer or the seller to remedy those issues to avoid it becoming a point of negotiation. So on behalf of Tina and myself, thank you very much for joining today and listening to us.